Virtual Lesson 1.1, Changes to the Law. The concept of law. The word law is used in many different ways, but probably the most common is as a reference to the set of rules by which people must live in a society. The study of law focuses on these rules. These rules are not arbitrary. They always arise from the will of the people. In a democratic society, they arise at least indirectly from the will of a majority of the people. There is a difference between rules that people choose to live by, such as being responsible for cleaning your room or doing the dishes, or a certain format for a game of tag, and laws that we have no choice about in our society. The police and the courts are responsible for enforcing laws, but not rules. Primary sources of law. The Constitution. The Constitution is the most important source of law in Canada. It is a set of rules that has been generally accepted by both the federal and the provincial levels of government. It contains statements of our fundamental values as a nation and creates the structure of our legal system. It is relatively difficult to effect changes to the Constitution. Common law and statute law. There are two other important sources of law in Ontario, common law and statute law. Common law refers to previous decisions made by judges, which are accepted and followed when similar issues arise. Statute law refers to legislation that is passed by governments. Common law and statute law may be in conflict, and in general, such conflicts are resolved as follows. A statute passed by a government will take precedence over previous common law in that jurisdiction. However, courts have the ability to interpret statute law in the way they see fit, and some courts have the power to decide that a statute is invalid and overturn it. The government may then attempt to amend and reintroduce the legislation, with the cycle continuing. The law is constantly evolving. The interaction between common law and statute law is just one example of how the law is constantly changing in response to the needs of society. Most historical changes in the law can be traced back to one or more of the following causes. Number one, demographic changes, such as population, urbanization, immigration, women going to work, etc. Number two, technological changes, such as telecommunication or air travel. Number three, changes in values, such as views on drunk driving, smoking, Aboriginal rights, etc. And number four, national emergencies, such as war, terrorism, or financial crisis. Prerequisites for legal change. In order for the law to evolve in a constructive way, three prerequisites must exist. Number one, respect for the rule of law. Number two, democratic government. And number three, independence of the judicial system. The rule of law involves the recognition that, number one, law is necessary in any society. Two, that the law should apply equally to everyone. And three, that the rights of the individual should not be limited except in accordance with the law. A democratic government is one that is elected by the people. It may then be voted out of office if it acts in a way that is not accepted by the majority and replaced with a more popular government. An independent judicial system is one where judges are free to make decisions without fear of punishment, such as losing their jobs or being jailed. To keep this freedom in check, the appeal system within the many levels of courts serves to ensure that decisions made by judges are reasonable. The impetus of change. Changes to the law may occur as a result of individual or collective action. Some individuals have successfully caused changes in the law by being very effective communicators or by taking extreme action that might have even resulted in imprisonment or death. The most common vehicle for change by an individual in recent years has been to challenge legislation as being in conflict with the Canadian Charter of Rights and Freedoms. The Charter came into force in 1982 and forms part of the Constitution. Many court decisions have involved striking down legislation that is deemed unconstitutional for being in violation of an individual's charter rights. People have worked collectively to bring about change through 4 different vehicles: lobby groups, royal commissions, publications, and political demonstrations. A lobby group works collectively to influence governments to support a particular cause or interest. They may also make efforts to raise public awareness of their cause, which may in turn influence government legislators. Lobby groups are the most effective form of collective action for stimulating changes in the law. When a cause has been brought to the attention of the government, it may appoint a royal commission to investigate the issue and prepare a report. The commission will meet with interested parties and do research in an attempt to gather information in order to inform and make recommendations to the government. The government is not compelled to act on those recommendations, but they are given a great deal of weight as new or amended legislation is considered. Legal experts and scholars may work together to publish books or periodicals that are geared toward the accomplishment of certain goals, such as environmental causes or furthering women's rights. Political demonstrations such as marches on Parliament Hill or Queen's Park are good ways to get media attention for a cause and therefore increase public support.